Welcome. I'm Rilus Dana. Today we're talking estate planning. We're going to be talking probate, what it is, how to avoid it. So this is going to be a basic estate planning for married couples. So let me share my screen here. We're going to talk about my friends, Mr. and Mrs. Estate. Let's see here. Oh, I gotta go. Google's not wanting to let it. Okay. I gotta restart Chrome. You kidding me? I just restarted. Hold on, let me share my screen. Okay, everything that I want to share, Google wants more preferences, I guess. All right, I'm back. Let's see if I can get my screen on here. All right, we got it. We did it. So let me share my screen here. We're going to be talking about Mr. and Mrs. Estate. I missing the other thing on there. Man, these settings, I swear, every time my computer restarts, I got to log back into everything, give permissions, give settings. All right, so this is our friend Mr. and Mrs. Estate, my favorite fictional couple. So this is where a lot of my estate planning meetings will start. So we send this before the meeting, this personal inventory. They get a link and we ask to fill out basic information, names, if they're married, do you have kids, how old are the kids, whose kids are they? Are they common to both? Are they one of the party's kids? And asset information. Is there any real estate? Approximately how much equity in the real estate? Types of accounts. So they have a savings account, a couple retirement accounts, checking, investment. All right. So if this couple came in to see me and we were talking, I would ask them, what was their motivation? Why did they come in? Why did they schedule this meeting? And sometimes people know, or sometimes people are asking if they need a trust or what they need. So I like to start with probate. So what is probate? So it helps to understand what it is to know why we want to avoid it and how to avoid it. So this example here, Mr. and Mrs. Estate, or this couple, she passes away. He's the beneficiary of her life insurance, so that will avoid probate. His name was on the house, so he's able to collect the house. But this bank account just in her name, what does she do with that? So a last will and testament designates who's going to be in charge as the personal representative and who the beneficiaries of the estate will be. It doesn't actually transfer the documents. So if he walks into the bank with the will trying to collect the account, the bank's going to say, hey, we need a court order. She's not here to sign, so we need something from the court saying that you're the right person, that you're authorized for the estate. So that's what probate is. It's the process to change title of an asset out of the name of the deceased. The reason that we generally want to avoid it is because it's time consuming and expensive. All right, so let's talk about a trust. So what is a trust? So a trust, it's a legal document made by a person. We call that person the trustor. And I use this briefcase to symbolize the boss, the person in charge. The trustee manages for the benefit of the beneficiary. The trust designates who the successor trustee will be and who the successor beneficiaries will be. So usually the person that creates the trust is all of the things. They make it, they manage it for the benefit of themselves. The trust designates who's going to be in charge, where it's going to go, and when and how it's going to get there. So let's take a look at the type of trust that I would do for a married couple. So we call this a continuation trust. All right, so they have a house, bank account, a couple retirement accounts, some life insurance. So they're going to create a trust. All right, so here's how it would work. So unlocked, meaning revocable, they have the power to change it. They're going to transfer their house into the trust and the bank accounts into the trust. Now, they're still the boss of the trust. They're the creators of it as a trustor. They manage it as the trustees for the benefit of themselves. Now, IRAs are controlled by the beneficiary designation, by the contract with that company. So IRAs do not get placed in trust typically. The I stands for individual, so it's got to stay in the individual's name. Life insurance, again, we look at who the beneficiary of that will be. All right, Mr. Estate passes away, this example. So first spouse goes. In this continuation trust, everything continues for the surviving spouse. That's why the name continuation trust. Surviving spouse is still fully in charge of the trustor, trustee, beneficiary, and it's still revocable, unlocked. So one spouse passes away. In this type of trust, the surviving spouse has full control over everything. So another advantage of the trust is that it designates, so time goes on, the IRA grows, and if the surviving spouse is incapacitated, this is the advantage I was talking about. So surviving spouse is incapacitated, gets Alzheimer's or dementia, then the successor trustee can step in and manage things as his bookkeeper for the benefit of the original trustor. So that's one potential advantage of the trust. It protects during your life, during the life of the trust creators. And then when they're both gone, then it's locked. Then it's irrevocable at that point. So the trustee will need to see who the beneficiaries of the trust are. The IRA gets paid directly to the beneficiaries that are, that are named in there. Life insurance. Usually I like the life insurance to be paid to the trust. I like the trust to be the beneficiary because it's paid income tax free. And then the trustee would distribute to the beneficiaries according to the conditions of the trust. So this example here, they get 1/3 at age 20, half at 25, then the balance at age 30. While they're under those ages, it's at the trustee discretion for health, education, maintenance, and support. All right, so they decide to sell the house in this scenario. The oldest beneficiary, over 30, so he gets all of his share outright. This 21-year-old, so since he's over 20, he's going to get 1/3, but the rest of his share is going to be held in trust for him. And this 18-year-old, all of her share is going to be held in trust for her. So that's the basic idea of a trust, and that's how it avoids probate. So since the assets are owned by the trust, the successor trustee is able to control these assets after the death of the trust creators, and they can skip the court process because they already have the authority. So there is some other types of trust, subtrust. So subtrust is the trust created by your trust. So this is what happens after they both pass away. Let's see. So I wanted to show some different types of subtrust. So this age trust is the most common type of subtrust. We hold things till the kids reach a certain age. There could also be a special needs trust or a supplemental needs trust. If a beneficiary is receiving benefits, public benefits or government benefits, you don't want their inheritance to disrupt those benefits. So a special needs trust allows the trustee to provide for the beneficiary, but not disqualify them from their benefits. A dynasty trust is a type of subtrust that gives the beneficiaries more protection. Basically, they get to eventually control their inheritance once they become the trustee. But with the dynasty trust, everything stays inside of the trust, so the kids have more protection that way. I got other videos on dynasty trusts if you want to learn more about those. We can also do education trust or even pet trust. We can give everything to a pet if you want. Okay, so in addition to a trust for a married couple, so this is we call it a welcome packet when people come in to meet with us. This has a little welcome letter. And then I like to show the timeline. So Mr. and Mrs. Estate, I've recommended that they need a trust. Before I show you the fees for the trust, I want to show you the process, how long it takes, and what's included. So the first meeting that we have together, we call it the personal family legal session. And then if we decide to go forward, I'll collect half of the fees, and then we'll start designing their plan. By designing the plan, I mean we'll talk about who the successor trustee and financial decision makers will be, who your healthcare decision makers will be, guardians if there's minor children, that type of information. And then after this meeting, the clients will have a chance to review that information and then approve it. After they approve the drafting instructions, there'll be the attorney review meeting to look at all the documents together and finalize them. If any changes need to be made, we'll make those changes and get everything ready to be signed. Then at the signing meeting, after all the documents are signed, we talk about funding, meaning what goes into the trust, how you fill up the bucket. So we talk about transferring real estate to the trust, how to change the ownership of bank accounts and investment accounts, how to update life insurance and retirement accounts. And then as part of this process, I really encourage to leave financial clues for your successor trustees, for the kids. That's going to make their life a lot easier if they can figure out what you own and what you owe. So I encourage people to leave records of that. There's two ways to do it. So we give you all the original documents in a binder. So you can leave your financial information here as well. And there's a section here to do that. And then we also provide what we call this digital vault. It's a license through Everplans to store everything electronically. So we have a login on our website to this. So up here, this digital vault, you'll see Everplans is a software company that powers it. And then once this is set up, you have an email and a password, and you can log in there, and you can decide who can access your information and who you let in there. So in addition to the trust, our trust package also includes all the contents of the will package. And with working with us, the main thing is you're getting an attorney to design a plan for you. The documents are kind of a byproduct of the service, but here's everything that's included. Last will and testament, so that's necessary to transfer personal property, who gets the Beanie Baby collection. Also, that's where you name the guardian of your minor children in the will. Healthcare power of attorney includes mental health care provision and living will. That's the pull the plug one. Financial power of attorney. And then the digital vault is included in the will package. Trust package is all of that, plus the trust. And then this digital asset language, this is something that's unique to us. Digital assets is defined as your information that's being stored on your behalf electronically. And this is important because less stuff is coming on paper these days. I started working in my dad's law firm about 20 years ago as a law clerk, and that's when I became aware of this issue. We'd get calls from the kids, and they would say, my parents passed away. How do I figure out what they owned? I found this 20-year-old trust, but how do I figure out where they're banking at and what they might own? Now, 20 years ago, the answer to that question was look around the house, see if you can find bank statements. And if you can't find any bank statements, start getting the mail and see what comes in the mail. Nowadays, less information is coming in the mail. So this digital asset language, we're going to allow the trustee to get information about the accounts. So, oops, where'd it go? So the information about your accounts is a digital asset. Now, the digital asset trust is a place to leave more specific instructions. For email, what I recommend is that we allow the trustees to get a list of emails received. So again, back in the day when everything was on paper, you could start getting the mail to see what someone owned or owed. So this is a modern way to do that. The other things are is if you're keeping photos and videos in places like iCloud or Google Drive and those types of services, you can leave instructions for those things as well in the digital asset trust. The digital vault membership's included, the funding meeting to talk about how to get everything into the trust. And then the package usually includes one deed. For California clients, there's just more of a cost to prepare California deeds, so there's that extra fee. Married couple, the fee is usually about $3,500 to do all of those things. And the last thing in here is this digital asset inventory and checklist. So most people don't realize they have digital assets or what they are. So this is the order that I like people to go through. Inventory, meaning what items are out there that you care about, that you store electronically. And then see if they have a way for you to transfer that account. If they include what's called an online tool, like Facebook has legacy settings where you can set up and that will control your account, or Google has inactive account manager. So I want you to see if they have one of these tools that works. Now for accounts that lack an adequate online tool, then we can name it in the digital asset trust. So for me, I don't want to name my 14-year-old, well I guess soon to be 15-year-old, but still I don't want to name him through Google. But I do want to make sure the YouTube videos that I have and the information on Google Drive gets copied to them, but I want my trustee to handle it. So I've mentioned in my digital asset trust to copy my YouTube channel, my Google Drive. I've also mentioned my Apple iCloud account, Dropbox, and those are some of the things that we do in the digital asset trust. So that's kind of what to expect if you're looking for estate planning. For married couple, a trust is usually recommended if you own a house or have some assets because we want to avoid probate. And then depending on your specific situation, your trust may need some other features or some other things. I hope you found this helpful. Stay tuned for other videos. Attorneys, make sure you check out the private attorney Facebook group. You can find links to everything on rilusdana.com. So there's links to for the attorneys, a private Facebook group. There's also a link there for a free estate plan. So no excuses. You can get your will done. There's a link on rilusdana.com for a free will. It'll take like less than 10 minutes to have a valid will. And then if you want something more complete, you can come see me at Dana & Associates. I can help you in Arizona and California. Thank you. Let me know what other topics you guys want to hear about in the future.